My name is Doug Doty. I am the statewide coordinator for the Montana Autism Education Project through OPI. About 2 years ago, Tim and Susan Bailey Anderson came to me. I'd been the autism specialist at OPI since '94 and said, do you want to do autism full-time? And I said, yes, I do. So they gave me a budget, and I'm now full-time on autism. So I want to just do a brief commercial about the project. We have a blog, and you have a handout at your table that I left. You can find the blog address on there. Also, if you Google Montana Autism Education Project, you can find the blog. We post all kinds of stuff on the blog, trainings in state, webinars that are done in state and nationally as well, all kinds of information about autism. So I think I just crossed 1,500 posts out there, and I update it several times per week at least. So lots of good information out there. There are areas where you can search for specific information like training, transition to adulthood, parenting, webinars, all kinds of stuff on the blog. We also do workshops through shops. I have 7 very part-time consultants who work for me across the state, and I mean, just in the last 2 weeks, they've been in districts from eastern Montana to Libby and out there and doing work. So all kinds of good stuff. We have consultants available to come out to districts at the district's request if they want. We can do consulting on individual kids. We can do classroom consulting. We can do training for staff. We've done a number of staff trainings this fall. So those are some of the things that we have available through the project. We also provide funding for speakers coming in for things like the CEC conference as well as other stuff. So I encourage you, if you have an interest in autism and want to avoid problems, above all, because it is such a highly litigious area now, contact us, work through the project. There is one piece of misinformation on here. My phone number has changed, and my phone number is right at the bottom. That phone number is a voicemail at this time. I don't know when it'll go away. My new phone number is 459-5303. So you can call me at 459-5303. Thank you.
One thing that we also have going with the early assistance program is that we, at times, when districts and parents have reached close to the end of their rope, we do offer to send in IEP facilitators who are experienced folks in the field of special education. And 4 of those folks are here today, and I just want them to stand up so we can see who they are and give them a thank you. It's Vicki Withrow, Jack Rudio, Mike Jakubchek, and Ann Verplugen. So, great.
But I do appreciate all the kind comments. I did get one suggestion for this afternoon, and that is to appreciate that some of you have some geography to cover later today. I know that some of you need to leave a little bit earlier. So what our roadmap is going to stay on the road, but we're going to change the order of topics. I want to finish some of the IEP issues that we discussed, and then get into behavior and discipline, and then kind of go back to some placement issues as time allows, bullying and harassment and an array of others. And then I would like to allow at least 15 minutes at the end for what else is on your mind. And also, if there's anybody who still wants more, I'd be happy to stay afterwards to answer any other questions that we don't get to. Do I hear any other suggestions or recommendations for this afternoon? Okie dokie. What I'd like to do is page 13, and I'm going to pick up the pace here to make sure we get through some of this. The Fort Osage case. The Fort Osage case doesn't really break any new ground. What it does is, I think, highlights, number one, you don't make decisions based on a category or label. In this case, the parent alleged that the IEP was inappropriate because it did not include the label of autism for their child. Now, the only time, and I'd like to have more time to discuss this, but the only time federal law requires a label be assigned to a child or a particular category is twice. During the evaluation process, during the eligibility determination, the eligibility report has to designate that the child meets one or more of the categories. In most states it's December 1st. What happens? Child count, where you have to do what? Check off a box of the child's primary category of disability. Those are the only times that the law requires that the IDEA requires that a particular category of disability be assigned. There is no requirement that the IEP include a category. In fact, I dissuade IEPs from including a category. It's just too easy in some schools. This kid is emotionally disturbed. Oh, we have a class for kids who are emotionally disturbed. Oh, this kid goes there. That's not the way it's supposed to happen. In this case, the court basically said that the fact that the category of disability was not part of the IEP, and in fact the district disputed whether in fact the kid was autistic, was of only attenuated relevance, because regardless, they said that the IEP was based on the individualized needs of the child, as evidenced by the... What should drive the IEP? The assessment data, the evaluation data, and that it was individualized based on the evaluation data, so even if the child had the category or label of autism, there was nothing to suggest that the IEP would have been significantly different. So therefore upheld the IDEA. Rodriguez, I'm going to go through this again fairly quickly, page 13, paragraph 10, no measurable annual goals. Well, if the department comes on site and reviews that IEP, you're going to be marked up for not having measurable annual goals. The court said in this case, it did not impact the provision of FAPE. We discern no error in finding that the flaw in the IEP did not affect the student's rights. As the district court explained, because the student was mainstreamed, the board or the school was able to measure her progress based on her grades and her performance on the statewide assessment and based on classroom-based assessments. In other words, and I don't want to give liberty or excuses for not having a compliant IEP, but the court said that since it did not include measurable annual goals, in this case, based on these facts, it did not deny FAPE, it did not deny her educational opportunities, because you were able to measure her progress based on her classroom work, her grades, her tests. You never look at just one piece of data, but you look at the whole picture. Therefore, there was no violation. Removing an IEP service. Just a couple things here. In particular, this was on a speech question. Can we rely on ASHA standards? Everybody know ASHA, the national organization. First of all, do we have related service providers here? PTs, OTs, school psychologists, etc. You are a very important member of a team. A team member should not be making any decisions of what's in the IEP or what needs to be removed from the IEP in isolation. That is a team decision, not a single service provider decision. It must be an individualized decision based on the student's needs, and the U.S. Department of Education said it would be inappropriate to use solely guidelines from a national organization to determine whether a child currently needs that service without looking at the individualized needs of that child. The Mahoney case, Ninth Circuit. In the Mahoney case, there are some procedural issues here. First of all, now, doing what just is legal is not always the right thing to do. It's the last time I'll say it. Kid had been speech and language impaired. The category of disability has now been changed to LD. You need at least one of the child's special ed teachers. The law was changed in 2004. It used to say that you have to have at least one regular ed teacher and at least one special ed teacher and service provider. Now it says you have no less than one. So you can no longer have a half a teacher or a half a special ed service provider. In this case, the child had the special ed teacher that attended the meeting was her previous speech and language pathologist. The court said there is nothing in the law that says it must be her current teacher or a teacher that's currently credentialed in her current area of disability, and that was LD. Now, so it was legal. But what's the purpose? I would want the child's current special ed teacher or provider there because we want to talk about how the child is doing now, not how they did 2 years ago. So although legal, as educators, I hope you see the law setting kind of a legal foundation, and you build on that foundation by making good educational decisions for kids. As parents, I could understand you wouldn't want all of your child's teachers and providers there. The law says at least one. Why? Because if I want all of my child's teachers and providers there, that may be the same time your child's supposed to be getting some service from that person. So that's why the law balances that and allows the schools to make that determination. This is the case that I made kind of general reference to earlier. The notice of the meeting indicated that the following people would be there. All these other people showed up. The court said that the parent failed to show how the additional other people impacted their ability to be meaningful participants at the meeting. Lastly, the parent said when we walked in, we were given a draft with draft goals and objectives for our child. Again, the Ninth Circuit said, so the law, the IDEA, defines a meeting under 300.501 of the federal regulations to exclude gatherings of staff that will be used to prepare for an IEP meeting or to discuss a parent's proposal that will later be discussed and decided. You do not have to start with a blank piece of paper at the IEP meeting. I like one case on predetermination saying the IEP team members don't need to come to the meeting without any thoughts. I know of nothing, I have thought of nothing. I strongly recommend, I highly recommend as an essential best practice that if you do have a draft of my child's IEP, send it to me ahead of time. Although you may not have any malicious intent, I walk in, I'm handed this document, I'm intended to sit down and, Art, do you have any questions or any recommendations for the team? I mean, it could be overwhelming. I think to truly treat me as a respected partner and to value my input, it makes a whole lot of sense if you have a draft to make sure that the parent has it ahead of time so they have the same opportunity as other members of the IEP team to review it, mark it up, think about it, bring their questions, bring their recommendations. Not a legal requirement, but a highly recommended practice. The court here said that there was nothing illegal about having a draft prior to the IEP meeting. The RP case, Ninth Circuit, and this case is on page 14, paragraph 13. RP versus Prescott, a Ninth Circuit decision. By the way, this case, there were multiple due process hearings. This parent has moved to another state where I do work and has now filed some due process cases. It's gone to court in that state. But in this state, the parent has a child with autism. Said there was no expert on my child's IEP team. The court says the law does not require an expert to be on the team. As a parent, I fully understand. I would like the best and the brightest people sitting at the IEP team table for my child. However, the court said the IDEA requires, in this case, there was a parent, there was a special ed teacher, there was a school district representative, there was an occupational therapist, there was a speech-language pathologist, there was a regular ed teacher. The IDEA does not require that the team include an expert. Secondly, on the issue of peer-reviewed research, the law was changed in 2004, the federal law that says the special ed and related services in the IEP have to be based on peer-reviewed research to the extent practicable. Oh, those are lawyer words. Now that we have all this research readily available to us literally at our fingertips, who can blame me as a parent for wanting what the latest research says is best in terms of addressing my child's needs. I have found out personally, and I'm sharing intimate information, that more information is not always better. I've had some medical issues. I get on the internet. I diagnose myself as having everything I read about. I had leprosy for a couple weeks. It took me a while to even discount some of the female problems I read about. I mean, everything I read about. By the time I get to the doctor, I am just in a whirlwind. He says, do not get on the internet. Do not. And of course, I just had some tests come back that weren't normal. So I get on the internet, and oh my gosh, I was in bad shape. And he goes, you know, the normal blood counts and so forth are based on the normal population of 95%. You're not normal. I said, I know that. But in other words, more information does not always add to or is better. The law here, the parents argued that the IEP for their child did not represent the best practices that have been demonstrated to be effective by the latest research. That in fact, the IEP as written would allow teachers to pick and choose the techniques they like, rather than to utilize these best practices. Quote, the IDEA accords educators discretion to select from the various methods for meeting the individualized needs of a student, provided those practices are reasonably calculated to provide the student with educational benefit. Lastly, the parents argued the educational benefit. The child was not making constant progress in all areas, under all goals. And a lot of the progress that the school reported was based on subjective measures and not objective measures. The parents alleged that CP was denied a FAPE because there was no objectively measured data collection requirements of his IEP goals, and it was based somewhat on teachers' subjective observations. The court found that there was both objective and subjective measures. And if I could, since I have your attention, and this is hard time of the day, I call it PLS, post-lunch syndrome. You know? The IEP has to have measurable annual goals. The IEP has to address how we are going to measure the child's progress under those goals periodically, and how are we going to report the progress to the parents. And I could just scream once again when I see over and over, how are we going to measure this child's goals? Data. Period. Data on what? I think you've got to be a little bit more expansive. Whether they're academic goals, social goals, communication goals, behavioral goals, data on what? How are we going to collect? What kind of data are we going to collect instead of data? And there's got to be some subjective measurement, even on a behavioral goal. If I'm a behavioral specialist and I'm going in and I'm observing periodically this kid, there's a subjective measurement of what I observe and how I observe it. This kid I see is getting up and not sitting in his seat, wandering around the classroom. My gosh, he's on the other hand, I could say, my God, look at this. He's able self-independence. He went over to the workspace or whatever. I mean, it depends on, in other words, sometimes there's a subjective element in everything. When I first got into this field, I had all of the standardized assessments administered to me, age inappropriate, but I wanted to find out exactly what they were doing, and I saw that it takes a judgment call on behalf of the administrator in terms of assigning a weight and a score, even in, quote, objective testing. For educators, we know that when a test shows that the child is reading on the 6.2 grade level, that's one snapshot. That's not the end all. But we parents, by the way, love it, unless our child's in 12th grade. But I mean, that's 6.2, not 6.3, 6.2. And so So I would ask you to be a little bit more sensitive on how your IEPs are addressing criteria for measuring progress. Secondly, the parents argue that the court erred in finding their child was making meaningful progress. There were some goals in which he made no or little progress. There are other the record supports the finding that the child did not progress at a constant linear rate in all areas, but he did progress. And I won't take your time. The court captures the evidence that supported that. There is nothing to say that in order to meet educational benefit, every goal the child has to be on a constant linear rate. Help me, non-disabled kids are going to be doing better in some areas than in other areas. Same thing with kids with disabilities. With that caveat, please understand, you have to measure progress periodically and report on that progress. Here we are in mid-November, October. Where am I? Montana. And this child has virtually made no progress since the school year started under their IEP goals. My first question is the IEP being fully implemented? Secondly, if so, why do we think that the child is not making any progress? We may have to call an IEP meeting before the annual review date to determine whether refinements or changes in the IEP are necessary. Don't wait until the annual IEP review to say, you know, we tried our best, but your child really has fallen short in all of the areas. So I would ask you this is an important part that I see oftentimes leads to frustration, disappointment, and at times litigation. By the way, if I could, I'm going to talk about this case in two places. I was going to end up on one of my favorite topics. My other favorite topic is attorney's fees. The court found in this case that the parents were motivated by anger toward the district. So the lower court awarded $140,000 in attorney's fees to be paid by the parent and their attorney to the school district. Don't write that down. And by the way, it actually says reasonable attorney's fees, but I've never seen an attorney's fee that I didn't think was reasonable. So, by the way, and this is later in your outline. Don't look there now. Where the Ninth Circuit overturned and said anger is a legitimate purpose for litigation. If you feel that your rights or your child's rights have been violated and trampled on, anger is a justifiable, motivating factor for pursuing your due process rights, as long as there are some reasonable grounds for arguing and you are not bringing the litigation without any factual basis. IEP team membership, again, this goes to the related service providers, because I've heard over and over again in some states, if you're going to be changing my area as a service provider, I must be at the IEP meeting. Not true. The law says not less than one special ed teacher or provider will be there. So let's assume you're the speech pathologist and we are considered changing speech, but we have the child special ed reading teacher who's going to be at the meeting. We could invite you, but there is no legal obligation that you be sitting at the team meeting when your area is going to be discussed. It does mean, though, that you should have some input. How was a student doing under this past year's IEP in speech? What does the last evaluation say? Why are you recommending that the team consider adding or decreasing or eliminating that service? But that person themselves need not be there to have a legally constituted team. Kid moves into your district from another district, either in Montana or the page 15, paragraph 15, or another state. This is kind of a new interpretation by the feds. The new district's IEP team must determine what services are comparable. The IEP team would have to determine whether the information that comes in with the child is sufficient to determine whether the child remains eligible in Montana. It's the IEP team. The IDEA and the regulations just says the new LEA. This is a new interpretation to say it's the IEP team. Letter to Finch. And to go along with that, a case out of the Ninth Circuit, bottom of page 15, top of page 16, Monrovia. It's the last IEP that's been actually implemented where you have to provide comparable services, not the last one that's been developed. I'm moving quick because I want to get through this material and get on to behavior and discipline. JW versus East Whittier. Now, the court didn't say this, but I went back and read the hearing decision. On the 58th goal on the IEP, the administrative law judge, don't quote me, but I think there were 77 goals in the IEP. People. You might as well just say, kick me, because someone's going to forget about goal 46 through 54. 77 goals? I saw a 106-page IEP. I asked the district, why did you do this? Well, the parent and advocate insisted. I said, why did you do this? It looks like a detailed lesson plan. IEPs are to be annual plans of present levels of performance, goals, services, where those the frequency and duration of those services, but how we carry out those services on a day-by-day or week-by-week fashion are details that don't belong in an IEP. I, the teacher or other service provider, need some flexibility. So if I'm working with this child and I'm coming in this way and it's not working, I need to be able to come in this way without calling an IEP team. In this case, after multiple meetings, the special ed administrator is writing the 58th goal because they're sending the IEP that I could only imagine how many pages. She said, I'm not sure I captured what the speech goal is supposed to be, so went to the speech pathologist after the meeting and said, can you help me here on this 58th goal and the wording of it? So the speech pathologist worked with the administrator in rewording that goal. The parent litigated to the Ninth Circuit saying that she was not made a meaningful participant in the IEP process. The Ninth Circuit overturned and said that the goal was discussed at the meeting with the parent present. This was simply getting the wording correct, not a change in the IEP. And the parent did get a copy of the revised IEP. Revocation of services. As you know, as of December 31st, 2008, a parent could revoke consent for services for their child who's been clearly found eligible. Curious, how many of you are working with families who've exercised that right? I mean, look at that. To be honest with you, I think that's one factor in seeing the decrease in the number of kids on IEPs. I don't think states keep data on that. I was in Arizona. There were 750 people in the audience earlier well, no, it was last month. It was September. I asked a question. I bet you 745 hands went up. I bet you there are thousands of children who would otherwise be eligible for special ed but are not receiving IEP services because the parents have exercised the rights that are afforded to them, and that is to stop services. This says that the revocation must be in writing. It's the revocation in their entirety. You cannot challenge me by requesting. One thing I don't understand, the law says you can't even offer mediation. Why not, since mediation is voluntary? They just issued another letter to Jim Girl, who's a hearing officer attorney out east, saying you cannot offer mediation. So then I'm suggesting you offer a facilitated discussion. I mean, I'm talking about kids here. Some kids who, by the way, and no offense, if a kid is on a speech-only IEP and I revoke consent, that child will probably survive. The calls I get are kids with concurrent academic disabilities and emotional, psychological, behavioral issues, and we can't provide all the services that the team just identified that the kid needs. The parent has a veto card. You must respond to the revocation in writing by sending prior written notice of the date in which you are going to the date on which you are going to cease services, and at any point the parent could subsequently refer the child back to special ed. Now, I saw some potential, so I actually submitted 32 pages of comments to these proposed regulations. And I said about reinstating the child, because I just saw the potential. And I said, I'd like to suggest that the parent could reinstate the child in special ed once per year unless the district and the school otherwise agree. To show you the influence I have, the feds said there is an unlimited amount of time. So I got involved in a case last year, child with autism, parent revoked consent 1 year, 8 times, and asked that the services be resumed 9 times. The child did not do well. Continuity. I mean, I don't mean to be treading on parental rights, but I'm thinking about the child. So when I was first born into special ed law, I was taught that this is not a parent's rights law, it's not a district rights law, it's a child's rights law. And I want to start with the strong presumption that a parent's decision is in keeping with their child's educational interest. But on those rare exceptions, think about this. This child is treated in essence as a ping pong ball. Now, by the way, the feds have said in particular, you may want to refer your kid back to special ed, especially if they get into a disciplinary problem. We'll talk more later. I get a call from Frank's counterpart in the state of Virginia, right after these regulations were issued. Mom and Dad, the Simpsons, got divorced. Doesn't surprise me with that hairdo, first of all. And Homer's not the sharpest tack in the... Anyway, in this case, the parents got divorced, had joint legal custody. This child had been on an IEP. The parent most involved was pleased with the IEP and wanted the services to continue. The other parent wrote to the school saying, I want services revoked. I get a call, well, the school called the Virginia Department of Education. Virginia called this hypothetical legal consultant. I said, the law really doesn't address that other than the law says we are not going to point to a particular date when all services must cease. It has to be within a reasonable period of time. So one of the things this hypothetical consultant recommended is that that notice go to both parents that the status quo will continue, meaning services will continue until or unless the parents both agree on a course of action or a parent provides us with a court order stating which parent's decision trumps the other. And I thought that was reasonable because it maintained the status quo. Excuse me. Sometimes it's better not to ask the question. Doug, who just retired as state director in Virginia, wrote to the feds and asked them for an advisory opinion. They said if both parents have equal decision-making authority and one parent wants services to terminate, all services must cease. Mark Ward, who is the attorney for the Kansas Department of Education, wrote again and asked them to reconsider, and I thought articulated a very well-developed and compelling argument. They reaffirmed their earlier decision. My concern is that not which parent should prevail. What happens to this kid? This kid will be treated as a non-disabled kid. You cannot provide any of the services. That kid, by the way, will not get accommodations on any of the tests. That kid will be treated as a non-disabled child for discipline purposes and lose all the protections of discipline. There's all sorts of ramifications there. I have to say, this upsets me. Our senator from Vermont is on the Senate Education Committee. When IDEA is up for reauthorization next, this is one of, I was told I could provide 10 pages of recommendations for reauthorization. My font is like 0.2. But this is one of them, that we revisit this. And I don't mean to trample on parental rights, but what about that parent with equal legal rights who wants the services to continue? By the way, if the kid had never been found eligible for special ed, and one parent gives consent for the initial and the other parent objects, I could agree then the kid should not get them, maintaining the status quo. So that was kind of my thought process in coming up with that, but the U.S. Department of Education disagrees. And you will see that those letters summarized on the bottom of page 16. Top of page 17, the AP case. All I want to do is that this cites a Ninth Circuit decision from 2007 regarding IEP implementation. And this really goes to my hearing officer friends. In these cases, the IEP was not fully implemented. Both the Ninth Circuit in the Van Dyne case and the AP court in the Second Circuit held that only major deviations from the IEP would result in denial of FAPE. And then they have this very enlightened statement that a material failure to implement the IEP is more than a minor one. Any questions? And they, by the way, I don't want you to walk out of here saying, Art says we just have to kind of implement the IEP. The court said, we want to note that the IEP is legally binding and the proper course to take, if it's not going to be fully implemented, is to propose changes to the IEP. I file a complaint with the Montana Office of Public Instruction that my kid's IEP is not being implemented. If any part of the IEP is not being implemented, you will be found. The department is legally required to find you out of compliance and order a corrective action. Remember I said, the legal standard that applies depends on which forum you use. This talks, in this case, and both the Van Dyne and the AP case, the IEP was not followed exactly as written, but the evidence showed that the child was progressing under all their goals. So the court held that the deviations, and based on those facts, were minor deviations that did not deny FAPE. But again, I'll just once again say it since I am on tape. I am not suggesting that you are not obligated to fully implement IEPs. You go to court and you prevail, you still lose. I mean, when I say you go to litigation, you lose or you lose big. You never win, even if you prevail on the issues, because of the adversarialness, the relationship is forever impacted. Here is a case, and then we're going to get on to, well, a few more issues on IEPs. Independent School District in Minnesota. Here was a kid with autism and Tourette's syndrome. And the parent wanted the child, excuse me, to participate in volleyball and some after-school clubs, and wanted the IEP to address the supplementary aids and services that would allow her to participate in those after-school activities. The team said no. The team said she doesn't need to participate in volleyball and these after-school clubs in order to get FAPE. So they refused to address it in the IEP. They filed a complaint with the State Department of Education. The State Department of Education found a violation that the Minnesota court upheld. A reading from the federal regulations, 300.117. In providing or arranging for the provision of non-academic and extracurricular services, and that includes such services as counseling, athletics, recreation, special interest groups, or clubs sponsored by the school, each public agency must ensure that each child with a disability participates with non-disabled children in those extracurricular services and activities to the maximum extent appropriate to the needs of the child. Listen to the next sentence. The public agency must ensure that each child with a disability has the supplementary aids and services determined by the IEP team to be appropriate and necessary for the child to participate in those non-academic settings. So really, under this IDEA provision, it's almost like a non-discrimination provision to the IDEA. This kid did not need to play volleyball in order to get FAPE. But if she qualified for the volleyball team, what additional supports and services does she need? Give you another example. Here's a child with a hearing impairment in West Virginia. By the way, she wanted to be on the girls' basketball team. Just because the kid's on an IEP does not give them, unless there's a no-cut policy, an automatic right to be part of the team. She was a very skilled basketball player and made the basketball team, and she wanted a full-time sign interpreter. The team said she doesn't need to play basketball to get FAPE. They used a section. The court held she was entitled to a full-time sign interpreter. Why? During practice, coaches set up plays, gives instructions. She was not able to access that without an interpreter. During games, what do coaches do? They scream and yell. But she was not able to access without an interpreter. The court held that that was a necessary supplementary aid and service. It had to be in the IEP, even though that was not a requirement for her to get FAPE. I've been waiting for these cases to come up because this is almost a non-discrimination provision in the IDEA. So there. We're moving on to FAPE. I see one question. Mary? There's one question or comment back there. Well, no, this is for the people in the cyber stream.
So I just do this anyway, but what about participation as, you'll appreciate this, an athletic supporter? A person that supports athletics.
Well, this takes me to new territory in terms, and I'm assuming we're talking about a male. I'm assuming we're talking about a male student.
No, I'm just saying the pet bus or something like that.
Oh, athletic. Oh, art. Did you think what I thought? People, work with me. The pep bus or whatever, it'll be the same thing. That those kids with disabilities have to participate to the maximum extent possible with kids who are not disabled. And if that kid needs special supervision or additional support, I think the team will have to consider it. I've seen the major issues on field trips. One more question and then we're moving on.
I'm jumping back to the one about the parents that had, the court had said that they're divorced but they have equal.
Okay.
Okay.
The court did not say that. The U.S. Department of Education.
No, I'm saying that they came in with equal rights to the child. Okay. So my question to you is, who are the attorneys for the U.S. Department of Ed that decided their decision? I mean, that would be my question.
This was the United States Assistant Secretary of Education.
Well, don't you think that person has an attorney?
I'm sure it went through some legal analysis. And to be honest with you, in all due respect, because I know the folks down there, I will go on record as disagreeing with their analysis that it's not based in law. There is another provision in the IDEA statute that says that the feds cannot establish new compliance standards through letters of interpretive guidance or technical assistance memos unless it's gone through the rule promulgation process. This did not go through the rule promulgation process. So I can't tell you to ignore it. They've issued it twice. I do plan on elevating the issue to discussion during the next reauthorization through our senator. Okay. I said I'm being a nice guy. I would like to be of support. You got me on that one. Okay. And then we are moving on.
Could the other parent then come back the next day and say, do a referral?
Yep. And then the next day the other parent says no. Then the next day the other parent says a referral. Then the next day the other parent says no. And where does it end? And that's what I'm saying. That's why my analogy, this poor child is being used as a ping pong ball. And in all due deference to parents, I have seen parents who have gone through some heated domestic relations disputes where the real issue is not whether this kid should get an IEP. The real issue is who's going to call the shots. But I keep thinking about this poor student who has exited in that one hypothetical 8 times and then added back 9 times. By the way, the kid had a full-time paraprofessional. Just as an aside, and I feel bad for you, but my first focus is on the kid. So you're the special ed administrator. This para needs to be added this week. Then I say no. Then we reassign the parent. Then 2 weeks later, the parent wants it. Then they say no. Then they want. First of all, my concern is focused primarily on the child. But think of all the other ramifications. And we've almost set up a process that begs for manipulation. I am going to move us to the top of page 18, paragraph 1, a case called J.L. versus Mercer Island, where the case in Ninth Circuit, Washington State, the court held that the IDEA educational or FAPE standard in Raleigh was no longer applicable because of post-secondary transition that was added in subsequent IDEA reauthorizations. Bottom line, the Ninth Circuit reversed and said Raleigh as we knew it is Raleigh as we know it. We would have thought that if Congress intended to modify the Raleigh standard when they reauthorized the IDEA subsequently, they would have said something somewhere in the legislative history. I am going to go to the KC and Drake cases, paragraph 3 on the bottom of page 18, top of page 19. The KC case, the court held that the student was not denied a FAPE because the IEP transition goals were not met. It was not, shall we say, an exemplary transition plan. But the court held, among other things, the student made progress based on multiple sources of data. Contrast that with the next case, the Drake case, where the court held that the transition plan was woefully inadequate. Every kid on an IEP has to have post-secondary transition addressed in their IEP no later than age 16. They started transition assessments and planning when the kid was about to enter 12th grade. By the way, this was not a kid who had skipped several grades and was 16, a 12th grader who was 16. Also, the IEP lacked measurable goals in the various areas. The finding that the student was denied a FAPE by the hearing officer was upheld by the court based on the inadequate transition plan. So I wanted to give you 2 cases that held differently based on different facts. The Ridley case. This is a peer-reviewed research case. And this, I see the peer-reviewed research case coming up primarily for children with autism and children with reading disabilities. In this case, it was a dispute between the Wilson Reading Program and Project Read. You could read this yourself, and ultimately the court said peer-reviewed research to the maximum extent practicable does not mean that the IEP must include the particular service with the highest pile of research supporting it. I will find research that basically supports or negates anything. Some of us remember, and I don't know where the research is, for kids who are dyslexic, if you put a colored, laminated sheet over the page, some of us remember that? That was good. Where did that research go? There was. There was one piece of research written by the person who proposed it, but it wasn't peer-reviewed. I mean, and what is peer-reviewed? There is no definition in the IDEA. Now, in higher ed, there's an understanding of what peer-reviewed research is. This came from the House of Representatives side of the bill during the last reauthorization. So I called one of the staffers that I know, and I said, there's no definitions, there's nothing in there as to why this was put in. Why was this put in? This is pretty much a verbatim quote. Well, I don't know, someone wanted it in, end quote. And that's how we make our laws. Here's what I think the intent is. I don't think it's too much to ask as a parent that you, if you are a school staff person, as a professional, that you stay abreast with the research literature in your profession. And I want you to be able to articulate when you are proposing a service for my child, why do you believe that service you're proposing is reasonably calculated to allow my child to gain educationally? And you don't say, because that's what we do for all our children with autism. And you miss the I in the IDEA. And there's a great case, and it's an older case from the Ninth Circuit called Adams versus Oregon. And it was regarding autism. And it was Julie Osterling, and I forget her colleague, Easterly. Anyway, there were two researchers that I understand are well known in the field of autism. And they looked at 8 different models of providing services to kids with autism. And they said there's some real different philosophical bents. But after we looked at these, here are the kind of the 6 core principles embedded in each of these models. The school then was able to articulate how those 6 core principles were represented in the proposal. The court said even though the parent wanted Lovas, the services based on the research of Dr. Lovas, which has also shown to be effective for children, the school was just didn't spin the wheel, and it ended up on this approach. They were articulating how the research by Julie Osterling and her colleague showed how those concepts were embedded in the IEP. The court said we can't ask anything more. By the way, the court also said you don't judge an IEP in hindsight. Anyone here ever make a decision where in retrospect you would have made a different decision knowing what you do now? In a lot of these cases, by the time it gets to hearing or even court, years have passed. Adams versus Oregon, and there's other cases out of the Ninth Circuit, has basically said we have to judge an IEP at the time it was developed, not what we know now about the child. Wouldn't it be great if we had that vision? Couple other fake cases. Here was a kid in New Jersey in a special ed class getting a 92-point grade average. This is on the top of page 20. The court said the grades themselves are not determinative. Infamous footnote 25 in the Raleigh case says grades are important, but they're not determinative. But in the footnote 25, they said if a child on an IEP is going to be in a regular classroom and getting passing grades and moving from one grade to another, that's one significant piece. The court used that and said, the Raleigh court talked about grades in a regular class. In this case, the curriculum and the grades were modified to such an extent that it was not a fair representation of the child's success. The A.B. versus Clark case. Here was a case where a child was touched inappropriately in a special class by another student. There were two male students, and they were in elementary school. And the parent of the student who had touched inappropriately obviously was extremely upset. And I believe it happened on more than one occasion. The end of the school year was just about there. They were about to go to middle school. Next year, the school said, "Mom and Dad, don't worry. The other student involved, he and his family are moving out of state." They did. And they moved back right before school started. So next year at the middle school, they were both in the same class. Well, that did not sit well with Mom and Dad of the student who had been touched inappropriately. So they moved the other student to another special class in the middle school, but on occasion they saw each other in the hallway. They never had any direct contact, and when they saw each other, they were always with an adult under adult supervision. The student who had been touched, when he saw the other kid, became physically upset. The parents said that denied FAPE because they didn't move the other kid to another school. The court held no. The court held, first of all, the school took reasonable supervisory steps, and even though there were a couple occasions where your son saw the other child, they were never left alone. And most importantly, under each of your child's IEP goals, there was evidence of significant progress. Now, as a parent, I want to guarantee that my child not only will be safe, but feel safe. Court said there are no guarantees. And the last case, here was a kid who had been in public school. The parents placed him in private school for a year at their own expense, or more commonly in Montana, maybe homeschooled. During that year, there was no effort to obtain any information on that student. Well, the parent then put the school on notice that they were returning their child back to the public school for the following year. So you understand? I'm going to make this up because I can't remember the grade level. 3rd grade, the kid was in public school. 4th grade, the kid was not in public school. The parents said, "We're coming back for 5th grade." The school made no attempt to get any information from the 4th grade year. Now, the kid was in private school, made no attempt to observe the kid, talk to the child's teachers, gather information, and used what the court said was outdated data to develop the IEP. The court said, among other things, the IEP has to start with what? The present levels of performance, both in academic performance and functional performance. You can't have present levels of performance based on data that's 2 years old. And therefore, FAPE was denied because the school made no attempt to gather current information. Questions on IEPs? I see 2 hands, and then we're moving to behavior and discipline. Way in the back.
This goes back to that, the case that you were just
You're going to have to
talking
please speak up.
Okay. This goes back to that situation you were just talking about. And in the case of a student who is homeschooled and the school is attempting to get data from the parent on homeschooling and the parent will not release or provide any data, do we just go off of off of the early assessments from this year? I mean, parent is refusing to do that, is what goes on in that case.
2 questions. My first question is, how old is the last assessment data that we have? Secondly, have we talked to the parent that what we want to do, you're asking that your child return to public school next year, so we want to make sure that we address your child's current needs, so we want some current information on your child. The parent doesn't provide it. What do attorneys like to see? Good, documentation. I was doing an in-service in another place, and I said, what do attorneys like to see? And someone yelled out, money, you know. My grandfather always taught me, you could only do your best. You can't squeeze blood from a turnip. So especially when a child was in a homeschool situation and we're asking the parent, who I'm assuming was the service provider during the homeschool, of information of at least what was the curriculum that we're using. Do you have any samples of your child's work that we could review? Or other, you know, I don't know what else to say other than if you feel that you have inadequate information, at least propose updating that evaluation through a reevaluation to update at least part of it. I don't know what else you can do other than your best, but you want to document your efforts.
Thank you.
And there was one last question.
IDEA talks about access to the general ed curriculum, involvement with, and progress with. Where do you see the reauthorization of IDEA going with that? And my other part to that question is, how do you individualize a standards-based IEP?
That is a very good question, especially as I believe Montana is one of the majority of states that has adopted the Common Core. Unless your state has per se required it, such as Arizona, there is no per se requirement that there be a standard-based IEP. The IEP does have to address services and supports necessary for the child to be able to access and progress in the general curriculum. I know that a few states say that each of the goals has to specify the specific state academic standard on grade level, blah, 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 blah. That I did not see that in Montana's regulations. Where do I see that going in reauthorization? First of all, there's this other law called No Child Left Behind, which is really the Elementary and Secondary Education Act. That law was to be revised by the Congress in 2007. That was a few years ago. That is going to be the first law that the Congress reauthorizes before the IDEA. The IDEA should have been revised in reauthorized in 2009. So it's going to be, I think, at the very least 3 years off. And part of it, the answer will be what happens in November. Are we going to be at what I call just like a political stalemate where we can't even agree that today is Thursday? Education used to be a bipartisan issue. No Child Left Behind was a bipartisan effort with co-sponsors on both sides of the aisle. I just find it sad that both sides of the aisle won't budge. And so, to be honest, I don't want to talk about what might be, but I definitely think we will, when reauthorization is on the agenda, see that issue elevated. What will happen? You know, by then probably Common Core will have been gone away and replaced by something else. I mean, I know in our state in the last 10 years we've had four different state academic standards. You can't even implement one before it's replaced by something else already. So we'll see what happens. We're moving on to behavior. And then we're going to take a very short afternoon break when the goodies get here, but we're not ready now. And by the way, this is intended not to be an everything you need to know about behavior and discipline workshop. That's a whole day workshop in and of itself. And my college roommate's a high school principal. And we've stayed really close since we graduated from college. We have gotten closer since he's become a high school principal. And I bet you a week doesn't go by without an email from Larry saying, by the way, what are your thoughts? This is intended to be an update. Before I talk about discipline, page 30, I have to talk about behavior. because the law sets a preactive expectation that if the evaluation results of a child show that that child's behavior is interfering with their learning or the learning of others, then the team needs to consider the use of positive behavioral interventions, strategies, and supports. And I know this, you know this, but I need to say it. The majority of our children on IEPs do not pose any significant behavioral challenges. There's a lot of kids not on IEPs who are a handful. Misconduct and disability are not synonyms. So as with any other decision, this is the IEP team's decision. Now I know in Montana, under your code, it talks about that a functional behavioral assessment shall precede the development of a behavioral plan. I have my cheat sheet here. Rule 10.16.3345. Do we have any school psychologists here? Now, the term functional behavioral assessment has certain meanings in the world of school psychology. I wrote to the feds, and I actually made the Federal Register. I was so excited. They didn't say by name, but they said a commentor. First of all, the term FBA in the IDEA is only used in discipline. The term FBA, as used in the IDEA, is not defined. The term FBA, as it's used in the Montana Administrative Code, I did not see a definition. The feds have said in the comments, because I basically asked, how are you using the term functional behavioral assessment? Is it intended to represent the functional behavioral assessment as really defined in the world of school psychology as kind of an in-depth probe, and I included all the elements? They said no. An FBA under the IDEA, we are not going to dictate what that means. We are going to leave it up to the team. Now remember, it's only used in discipline under the IDEA. And let me just give you one example, and then we're going to get to behavior plans. Here's a kid on an IEP for speech. Tomorrow night at the football game, he is drinking beer. Hopefully he did not get it from a faculty member. Let me just ask you, if a student is using or possessing alcohol or substances at school or at a school function, what's the typical disciplinary sanction in your school? Suspension for how long? 45 days, 5 days. I mean, did I hear 45 in one case? People, time. So let's assume that the kid, let's assume it's 10 days. The kid's already had 1 day of suspension. Let's assume you have to do a manifestation determination. And we're all sitting down and we're looking at this kid, both I, the dad, and you, the school. The kid has not been perfect in school, but we really have not had any major behavioral challenges with this student. Do we automatically have to conduct a functional behavioral assessment as defined by a school psychology textbook? The feds have said no. If we say, you know what, this is kind of an isolated incident, poor judgment call by this adolescent. It's been known that adolescents sometimes make poor judgments. By the way, it's been known that some adults make poor judgments. Why are we going to necessarily probe an in-depth look at the antecedent behavior, blah, 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 blah. In another case where here's this kid in October, this is not the same child that we've known. Something is going on. We may need to probe much further and have a much more in-depth assessment that does look like an FBA as defined in the school psychology textbook. Regarding, and in fact, I'm going to share with you where the court in Kansas, well, let me share it right now, because we're going to jump back and forth to keep you awake. If you turn, it's called the JW case, page 32, paragraph E. This was a case out of Kansas. And among other things, the school argued, the parents argued that the behavioral plan was not appropriate because it was not based on an FBA. The court said, the court nevertheless will evaluate where other than circumstances the failure to perform an FBA, by the way, the Kansas code also requires an FBA as, before a behavioral plan, constitutes a procedural violation of the IDEA. In conducting evaluations, the IDEA requires a district to use a variety of assessment tools and strategies to gather relevant functional development and academic information. The IDEA instructs that schools shall not use any single measure or assessment as the sole criterion for determining an appropriate IEP. In the case of a child whose behavior impedes the child's learning, the IDEA requires the IEP team to consider the use of positive intervention supports and other strategies to address that behavior. There is no requirement that a particular assessment tool be employed in evaluating a child. This court will not impose that requirement. Thus, the court finds no procedural violation of the IDEA by failing to conduct an FBA. Even if the failure to conduct an FBA constituted a procedural violation, the parents have failed to establish that such defect affected the student's substantive rights. Even assuming without deciding the functions of the child's aggressive behavior, the school had sources of the child's behavior from multiple sources that they use in developing the behavioral intervention plan. Go back to the first case out of New York, the CF case. The New York State Code, and I happen to do work in New York. I have 50 state special ed codes in my home. So on a Friday night, open a glass of wine, I ask my wife to say, pick out a state. And then I read excerpts of their special ed code. And then she pours more wine. You mean you don't? If you look at the CF case, where in New York they specifically require a functional behavioral assessment. But New York even goes beyond Montana in defining what a functional behavioral assessment is, which you don't specifically define in your code. In this case, the court upheld the behavioral plan even though a functional behavioral assessment had not been conducted. The parents argued that the IEP was inadequate and insufficient. Although the IEP did include a behavioral intervention plan, no FBA had been conducted prior to the formulation. However, the court goes on to say that the IEP team had access to a substantial amount of information about the child's current interfering behaviors, which reflected the behaviors and provided for the continued use of intervention strategies that the parent's independent evaluator recommended. And so forth. So in other words, and I'm not an attorney licensed to practice law in Montana, I am not a spokesperson for OPI. I am not a spokesperson for the Montana AG's office. I am a spokesperson for ART. As with any other component of an IEP, I strongly feel that there should be a direct line between the evaluation data and the contents of an IEP. But the term FBA sometimes has a certain connotation, just like the term RTI. And I think it will be up to the teen, if behavior is a challenge, to determine what a behavioral assessment will look like. The question is, what are our concerns about this child's behavior, and what do we need to do in gathering information to be able to be given information to be able to address those concerns? And it may indeed be a formal FBA. But the Fed said we are not defining the term FBA. We're leaving it up to the team. And help me if I misread your code. I didn't see anything in your code that talks about what an FBA is. And I know this has come up. And in fact, when I was in Seattle, someone came up to me from Montana and says, I wish I could be in Helena, but I understand you're coming into our state. And I said, yeah. She said, there's been some discussion and parent controversy. Some people saying that the behavioral intervention plan does not need to be part of an IEP. Others says it has to be part of the IEP. Here's what Art says, that Art's reading of the law. And by the way, there's a brand new case that came out yesterday from Rhode Island. I read cases every day. I get on the Ninth Circuit website every night. Does anybody have a referral form? An IEP has to identify what? Present levels of academic and functional performance, which to me includes behavior. And if behavior is interfering with their learning or the learning of others, I think I'm going to look at the IEP. Do we have a goal for behavior? And do we have a section in the IEP that says what we're going to do in terms of positive behavioral interventions, strategies, and supports? What we're going to do, I think, has to be part of the IEP. How we're going to do it doesn't. So it really depends on how you are defining the term behavioral intervention plan. Now, I've talked to some psychologists, and I've seen some very, very well-developed behavior plans that talk, for example, on timeout, the different levels of timeout, what will be, how to address that, how to implement the various levels of timeout. We want students to become ultimately independent. So if I see the student's behavior escalate, depending on the student's developmental ability and age, I may try to give the student what? Some nonverbal signals just so they become a little bit self-aware. In other words, it doesn't and there's various stages of timeout. I've even seen some behavior plans include scripts, because what's key here? Consistency. Kind of scripts on how to respond to the student. To me, those are all details of how we're going to do it that don't belong in an IEP. What we're going to do, just if I can make the analogy, this kid has a reading disability. We have a goal in reading. The kid's going to get 30 minutes of reading in the resource room every day. What we're going to do every day for 30 minutes are not details that are described in the IEP, unless you have a 106-page IEP. That looked like a lesson plan to me. So it really, in Art's opinion, depends on how you're going to use the term behavior intervention plan. Now, if you live east of here a little bit, the 8th Circuit, based in Minnesota, Iowa, Nebraska, may I say, in all due respect to the court, I'm an officer of the court, they got it wrong. They're saying behavioral plans under the IDEA don't even need to be in writing. Do you know it when you hear it? And I'd like for them to part of in discipline, if the kid gets in a certain disciplinary episode, so to speak, with the frequency, we have to do what? Review and revise the plan? How do we review and revise a plan that's not even in writing? much less part of an IEP. See, I think, based on the testimony in that case, they're using the behavior intervention plans to talk almost like the daily lesson plan type of thing instead of a behavior. So Art would say, I want to, and in fact, the case that came out of Rhode Island yesterday found that the IEP was deficient because the kid had significant behavioral problems. There was no behavioral goal. Behavioral goal and what we're going to do, how we're going to do it, separate. I talk about a behavior intervention plan as opposed to a behavior implementation plan. And by the way, if you look, it doesn't say behavior management plan, because the real focus and goal is not to manage inappropriate behavior, but to do what? Instill and strengthen appropriate behaviors and social skills. Questions, comments? If I could, the JW case. I want to get into behavior. The JW case. I'm going to talk about two cases and then we're going to take a break. Paragraph E. The JW case. The parent alleged that the behavioral plan was inappropriate because the kid still had significant behavioral issues. The court understands the parents to argue that JW's programming failed to provide him an educational benefit because it did not prevent his behaviors from substantially interfering with his learning. There is dispute on this point. However, this is not the standard by which a court will evaluate compliance with the IDEA. The IDEA contemplates that some children will have behaviors that impede or interfere with their learning. The IDEA does not require a school to eliminate interfering behaviors. It requires schools consider the use of positive interventions and supports to address those behaviors. As we previously discussed, the school has met this responsibility. Now we want, with these interventions and supports, those interfering behaviors to lessen and hopefully evaporate. But as with every other IEP, there's no guarantee. One last, is it okay if I take a break before 3 o'clock? Oh, well, all the stuff is back there. There's one other case, though, that I want to talk about. How many of you have ever been a, teacher in a special class? Here's a child who has an intellectual disability and an emotional disturbance. She is placed in a self-contained special ed class for kids with emotional disabilities. This is a BH case that I have included on the bottom of page 30, top of page 31. And the school put together a point system for the class. By the way, the school was asked by the court, where did you come up with this? They said, well, PBIS. Anybody who has some background in PBIS? I want to ask you after this is over if this meets your definition. The point system in the class. Now remember, this child had concurrent an intellectual disability and an emotional disability. The point system in the classroom required the student to acquire a certain minimum number of points every day, with each point total differing for different activities, and to achieve those numbers for 8 consecutive days in order to move to the next level where additional privileges were afforded. The student could earn up to 2 points for each of 5 different behaviors: following directions, staying in your own space, being on task, positive peer interaction, and positive staff interaction for each of the 7 periods of the day. Those points were subtotaled. The student then can earn up to 7 points for her 3 personal goals: communication needs, using sensory items correctly, and completing tasks in a timely manner. She could earn up to 5 points for bus behavior and 4 points for recess. In fact, the teacher could also dock the student points. In fact, the student was docked points while sleeping, even though she had a poorly controlled seizure disorder and took medication that caused sleepiness. At the end of the day, the points were totaled and deducted out of a possible of 100 points per day. If she made her day depending on what her IEP required, then she had to reach that for 8 consecutive days for her to reach her next level of privilege. The court said, I don't understand this. First of all, I'm a teacher in a special class, and special classes usually have smaller numbers than a regular class, but do I keep a counter on my belt? You get 2, you get 1 for the, minus 1, you'd get 2 divided by pi. I mean, and then how does the teacher for bus behavior, and I mean, practically, and she said, well, that's PBIS. Your response? Well, there's no there was, and I failed to add, this student had been physically restrained several times a day. In fact, one day, 8 times in one day. Parent was never informed, often done as punishment for the student. Why this case even got to court instead of a letter of apology, but that's not PBS as I know it as a layperson. And just from a pragmatic perspective, how would you as a teacher be able to keep track of all the points of all your students and deduct and add and subtract and divide? The court threw it out as a positive behavioral system because of just the pragmatic. And here was a kid also with an intellectual disability. How was she supposed to understand all of this? Any closing questions on behavior plans before we break, and then we're going to come back to discipline? Going, and here, since we started a few minutes late from the afternoon, I'm going to make a 15-minute break into 10, and I'll be back in 10 even though you're eating your cookies. Go.